This is Occupier Kaylin coming to you live for the second day of Back in the Pipeline Deliberation by the Iowa Utilities Board. We are in their hearing room, in their headquarters, and we are waiting for the board members and their staff to come in. And because the weather is somewhat nicer today, although very cold, just not as windy, we are expecting that this room plus the overflow room to have more people in it. So the format will remain the same. The parties who have an active stake in it, those for and against the pipeline, as well as members of the public who can fit in here, as well as any press who shows up can observe it. And so I am live streaming for the second day, and I will come every day, at least through Thursday if they go that long. Friday I go to the mosque, so I won't be able to do it if they go on Friday. So if I can get someone else to come in here and stream Friday, hopefully I can. Otherwise, I don't know if anyone else will be recording. There is an internal stream that's being fed into the overflow room, and it will be streamed on the Iowa Utilities Board website, I believe. Yeah, they have a Ustream account, but I've chosen to stream it again. And a bit of good news. The annoying light has been taken care of. The bulb itself has been taken out, so that won't bother anyone today.
The Iowa Utilities Board is back in session on briefing and deliberations for HLP 2014-0001. We are going to proceed with our outline. I would like to remind everybody in the audience that this is a time for the board to have a briefing from staff on all of the legal issues, as well as staff to ask questions and direct our staff attorneys to receive forward preparation of materials in this case. At this time, I'm going to turn to Mr. Rice, and he may proceed.
Just to kind of recap to make sure everybody understands where we are on the issue list. We have gone through those issues which are listed under Roman numeral 1, which went down through the legal standards, global issues, national issues, state issues. And we've now come to the issue with regard to the specific route proposed by Dakota Access. Now, before we go on, I wish the board did have a question yesterday about county inspectors, and I have obtained some information, and I can pass that out now, or we can deal with that maybe when we get later into the route issue, or we can do that separately.
It's your call.
Okay. Why don't we wait, and maybe that will come up as we go, as we discuss the route, and if it does, then I can pass that out at that time. So, in looking at the route issues and those issues which we've listed under Roman numeral 2, in designing this, I think the intent was to look at the eminent domain parcels after we talk about the overall route issues. But because of some of the legal issues raised by the parties, it appears to me that maybe we need to go through those legal issues on eminent domain before we get to the actual route issues. And so I thought I would begin there today with the legal issues that have been raised. And so just starting with the statute itself, which is 479B, as everyone is aware, eminent domain is mentioned in two places. And one of those is 479B1, which indicates at the end that the board can grant rights to eminent domain where necessary. And then you go to 479B16, and there, as we've discussed yesterday, it states a pipeline company granted a pipeline permit shall be vested with the right of eminent domain to the extent necessary and as prescribed and approved by the board. And then it goes on to describe how much, at least in the statute, it determined was a reasonable width for the pipeline easement. And but the statute also does provide that the board may grant additional easement rights if a right of way if the board finds that necessary. And I think rather than discuss that now, that will come up again when we get up to the overall route of what Dakota Access has asked for, because they've asked for easement rights or right of way under eminent domain broader than 75 feet. So then going to the legal issues themselves, there's really two or three aspects of this, and I'm not going to try to do I don't know what you call it, a white paper on eminent domain, but I'm going to try to hit the highlights. So the first, I think, issue that we need to talk about are the constitutional issues, where it is found in the Constitution. And the first is the U.S. Constitution, where it states that there are actually two pieces to it, and one is it has to be for public use, and the other is just compensation. And as the board is aware, and all the parties are aware, the board doesn't address the issue of compensation. That's really for any eminent domain proceedings that are taken before a county compensation commission. So with regard to the issue of public use itself, there is a recent, I guess it's not recent anymore, but it was recent, the case of the U.S. Supreme Court with Kelo versus City of New London, Connecticut, where they kind of laid out what is the current standard under the U.S. Constitution for public use. And there are actually three aspects of that which they look at, and that's public ownership, public use, and public benefit. And then the Iowa Constitution has similar language, which it talks about private property may not be taken for public use without just compensation. And so that they have a little different language, but they really have the same two pieces with regard to, if you want to take by eminent domain, it has to be for public use, and you have to provide just compensation. And the issue always that usually is, and the issue here is the Dakota Access Pipeline of public use. Now, the parties who oppose the pipeline have raised several issues, constitutional issues, with regard to the pipeline. And some of those issues involve equal protection under the various statutes, and some of that involves Iowa Code 6A, which is the condemnation statute. It discusses the rights of the landowner to seek judicial review before condemnation proceedings, and also whether 479B16 provides fewer protections than 6B21. And so there's some equal protection arguments there that have been raised by the parties. I think the board will have to address those whenever they make their decision, but if you go, the recent Iowa Supreme Court case of Hawkeye Land Company versus the Iowa Utilities Board, I think it's kind of illustrative of the approach the courts take to constitutional issues, and basically they try to address any issues before them under the statute and don't reach those constitutional issues unless they have to. And that may be an approach that the board wants to address, even though they may address those constitutional issues. I don't know if the board will want to actually reach a decision on those, because as the board is aware, the courts take any constitutional issues de novo, and they may look and see what the board has in how they interpret the statute, but really they look at those constitutional issues on their own and make those decisions, as they say, de novo. And that brings us to the statutory issues. And there's a basic tenet of administrative law that an administrative agency only has the authority granted by statute. And so the question is, does the board have authority under 479B16 to grant this pipeline, to grant a permit? And the argument from the parties who are opposing the pipeline argue that Iowa Code 6A21 limits the board's ability to grant eminent domain rights under 479B16. And the issue there is that in 6A21 there's a limitation there that only certain types of entities may take agricultural land for public use. And the specific language that is in dispute and that is referenced comes out of 621 1C, which states that a public use or public purpose or public improvement does not include the authority to condemn agricultural land for private development purposes unless the owner of the agricultural land consents to the condemnation. And then you move to 6A22, 21, subsection 2. It states the limitation on the definition of public use and public purpose or public improvement does not apply to the establishment, relocation, or improvement of a road, etc., etc. And then at the bottom it says, this limitation also does not apply to utilities, persons, companies, or corporations under the jurisdiction of the Iowa Utilities Board in the Department of Commerce, or to any other utility conferred the right by the statute to condemn private property or to otherwise exercise the power of eminent domain. So that's where the dispute arises, and several of the parties who oppose the pipeline are arguing that limits the ability of the board to grant this pipeline because because it's going across agricultural land, and Dakota Access does not come within that limitation. So those issues are presented to the board, and basically are two of them that they have raised, and one is whether the pipeline or Dakota Access comes within the jurisdiction of the board, and the other is whether the parties have argued that they're not a public utility. Excuse me. And the jurisdiction question really comes down to, as the board knows, the board has authority over siting and can put conditions on the route, but they don't have jurisdiction, have been preempted jurisdiction by PHMSA and by the federal government over safety. And then the argument then is, does the jurisdiction in 6A21 mean the board's jurisdiction over routing, and does it include that? Or is it limited to the safety jurisdiction? And that's something the board will have to consider whenever they take up that issue. That's the kind of legal issues that the board will need to address in the order, I believe, and in order to decide whether they can move forward with the case. And the part of that where that comes in is, and we were talking, I think yesterday, about what is public convenience and necessity, and we're talking about what things are included in there. And I think the issue of public use probably is part of that discussion, and so you almost have to at least address these statutory arguments and legal issues before you can reach the issue of public convenience and necessity.
Mr. Lynch, I have a question on with procedural, because this issue also was raised in our Cherokee case, and I would like you to explain to the board, more for the public at this point, but the process then for instances where we have litigation, and just tell us what we have to follow, what can be discussed in public, what we may need to go into closed session as it relates to litigation.
Well, in that particular case, the Cherokee County case involved some landowners, many of whom are parties to this case now, who filed a challenge directly in district court seeking a declaratory judgment that under the arguments that Mr. Wright has outlined, that the board lacked authority to grant eminent domain to Dakota Access. And the board responded in that case with a motion to dismiss, arguing to the court that that issue needed to be considered here first by the board before the court could look at it. Once the board has made that decision and has decided what your interpretation of the language from 6A.21 may be, then that again will be subject to judicial review. Whichever way the board goes, whichever party disagrees with it can take that back to district court, and not just in Cherokee County, but in any county where the proposed pipeline would go through. So that one, the district court agreed with our motion and granted it, and the parties, most of them at least, intervened in the board proceedings and participated in the hearings in Boone in November. In terms of the procedural question of what we can talk about and what we can't, when a matter is in litigation, the Iowa Open Meetings Act does allow the board to go into closed session to receive advice from its attorneys regarding matters that are in litigation. Because that case has been dismissed and no appeals were filed, that one's kind of off the books for purposes of the case here today.
for us then to discuss with you our interpretation or our belief as to what the statutory authority is related to what Mr. Wright has set out. Is that in public or is that in?
You also have the option to go into closed session to discuss matters that could be subject to further litigation, or in any case, you have, in any case like this where you're making a decision in what is defined in under Iowa law as a contested case, the board has the ability to go into closed session to consider the decision to be rendered in that case, as long as you come back into open session at the end for any final action.
And the statutory authority for that is in
21.5F, I want to say, but
I won't hold you to
my memory's not well done, so.
it. Mr. Wright.
So that's the legal issue that I felt like we need to address before we move to the route itself. And I'm going to go into a little detail with regard to the overall route, just so we kind of remind us of what we're dealing with, and there's several issues raised by the parties opposing the pipeline on the overall route. First of all is the statute in section 479B5 does set out a list of information that someone seeking a permit under 479B needs to provide. And really there's only two of those that I think are the subject of the opposing parties addressing, and those involve the possible use of alternative routes and petition whether to address the inconvenience or undue injury which may result to property owners from the project. And with regard to the alternative routes, and those you probably remember for the hearing and from reading the testimony that Dakota Access witness Howard, I think, went into some detail of this, and the board even asked, I think, for some of this information. But Dakota Access used a graphic information system software program to evaluate potential alternative routes based upon parameters that Dakota Access provided to the company that actually owned the program. And the data sets utilized by Dakota Access included engineering, environmental, and land use. And the evidence showed that engineering includes location of the existing pipelines, railroads, karst landforms, and power lines. Environmental includes critical habitat, fault lines, state parks, national forest, and national registry or historical sites. And land use includes dams, airports, cemeteries, schools, mining, and military installations. So, and then each of those data sets was then weighted as low, moderate, or high based upon perceived risk based upon the engineering, environmental, and land data sets that I've just described. And Dakota Access explains that the preferred route would follow features identified as low risk or, where necessary, moderate risk, but would avoid high risk locations. Dakota Access attempted to follow the shortest route, which, if you don't mind, I'd like to put just up on the screen, just to show you, as we discuss this, where I know you've all seen the route, but I thought it might be beneficial. And I'm going to try to use the technology desk in a similar fashion that we used at the hearing, although the attorney said they're a lot more successful than I think I may be. But we'll see. And as you can see, the route takes a diagonal all the way across the state. And in looking at the route, or the preferred route that Dakota Access proposed in their petition, they chose this route, I think, basically they say for two reasons. One is the shortest, and also it followed at the data sets and the evaluation that I would describe them, and allowed them to propose a pipeline which had the least interference with land use and other high consequence areas, and also the shortest distance, so it also reduced the overall cost of the pipeline. And Dakota Access witness Howard testified that the proposed route was modified in multiple locations to avoid wellhead protection and HCAs, or high consequence areas, wetlands and water bodies, certain cultural resource sites, home and farm sites, buildings, irrigation systems, power poles, towers, other structures, and property corners. And according to Howard, the route modifications were also made based upon aerial imagery, actual site visits, and helicopter reconnaissance. In addition, the specific weighting and the types of property to be crossed are shown in the Iowa Farmland Owners Association Exhibit 5, which lays out the specific weighting and the actual list of items that were considered. And I don't know if that's pretty much detail. I don't know if it's worth putting that up or not, but we might just show that to show how that was evaluated. I don't know if you can kind of see there the topics that were addressed. You can see how they're evaluated on the side, where it shows avoid, exclude, etc. as you go down that, and that was the IFLOA Exhibit 5, shows those. Now, the parties who oppose the pipeline have raised issues about going or using a diagonal pipeline or diagonal route. And one of the main issues that was raised is when you cut diagonally through all of the agriculture and farmland in Iowa, you run into their individual farmers' tile systems. And so, as you remember the evidence and the testimony from the hearing, the issue of tile systems and how you're going to avoid the tile systems or go under the tile systems and repair the tile system were all issues that there was a lot of testimony and a lot of issues raised by those farmers about how those tile systems were going to be not only avoided, or if they couldn't be avoided, how they're going to be repaired during construction. And so that's one of the issues they raised. And some of them raised the issue, why didn't the pipeline go straight down north to south and then make a right-hand turn and go east to west? And the board is going to have to evaluate, I think, those arguments in terms of the statute, which requires the use of alternative routes. First, they'll have to decide exactly what that term means, and then they'll have to weigh those arguments with regard, was there a better way to construct this pipeline or than as proposed by Dakota Access with regard to the diagonal route. Now, neither the statute nor board rules require a specific weighting of the individual items that's listed on IFLOA Exhibit 5. And so, but if you look at that list, and I think this is one of the arguments that those opposing the pipeline have made, is you don't see tile on that list, I don't believe. So, you know, that may be significant, it may not. The board, that's something the board will have to weigh. Now, there are other individual issues with regard to the overall route, but that's basically the issue if you're just looking at the overall route, of whether it should have been diagonal or whether it should have been either north to south, or the other issue that was raised was, if you probably are aware in 478 with regard to transmission lines, they're required to be along division lines or road right of way. And there's another argument that this pipeline should have been routed as much as possible along division lines or along road right-of-ways. And that's another issue that the board will have to consider when looking at this, is should Dakota Access have followed more of what 478 prescribes rather than a entirely diagonal pipeline.
Ms. Jacobs, do you have any questions?
I do. Just on the option of an alternative route. There was no alternative route presented. It was the one route using the data sets that you showed. That's correct.
That's correct. I think the only alternatives were where the route was modified at individual locations to maybe go around something that had not been anticipated, or where a landowner asked them to shift the route. But as far as you're aware of the transmission line cases and some of the other pipeline cases we've had where there was actually a whole separate route laid out, and that it was not done that way in this case.
And then on a little different topic, you mentioned 478 and the transmission requirements for siting transmission lines to follow right of way and on the division lines. I'll show you with my hand, but that's pretty much good. But there really is nothing else in the code that gives guidance for pipelines. So it's not really comparing apples to apples when one looks at what's in 478. It's just a potential suggestion, but not really apples to apples.
Yeah, the statutory language is different, and those requirements are not in 479B. So I think the argument is, though, that you should really follow that, because that's a more reasonable way of developing a route. But it is not; those requirements are not in 479B.
479B require that they submit an alternative route?
There is no specific requirement about how they address the issue of alternative route,
But it is required in the application.
that they at least have considered alternative route. And I think Dakota Access, in their evidence, has presented that our GIS program and are looking at and trying to avoid those areas which that they think are high consequence or environmentally sensitive, that really complies with that provision.
Is that what the board believes the intent of that provision in our administrative? I mean, is that what you, as the attorneys for the board, believe that the statutory intent of alternative routes meant in our rules?
I think, and I'll let Mr. Lynch give you his opinion, but since the board has not actually addressed this issue with regard to 479B, I don't know that I'm prepared to give you what I consider to be a legal opinion on that issue.
What about a non-legal opinion on what is meant by the board shall review the route? Does that mean we get a choice? Is cost the premier thing we're looking at, or is it? I know high consequence area, I know high sensitive area, I understand that concept, but does cost play into that, or if it's more appropriate for landowners for it to go in another area, do we have the right to say that?
Well, I think you get to look at the overall route and the various components of that route. I think cost is an issue. I think safety is a big issue. With a transmission line, you can kind of go and down and turn at a right angle, and it doesn't affect the overall performance of the line as much as with a pipeline. There is an issue of turning a pipeline underground at a right angle or approximate right angle, and how that would affect the company's ability to inspect it with the new technology, which is called Smart Pig, where they run something through the line.
But when you weigh that against the rights of landowners to be able to have tile lines that actually drain and allow them to use that land. How do you weigh that?
I'll let Mr. Lynch answer that.
I think it goes to the overall question that we talked about yesterday, the public convenience and necessity and the weighing of the various factors that are going to be there. And in the end, it's going to be the board's judgment based on your knowledge, the evidence in the record, and your knowledge of Iowa and the imposition that a pipeline would represent on Iowa land and landowners to make a decision about whether this, when you take all the pluses and minuses and put them in balance, does this project promote the public convenience necessity? And those are going to be hard things to balance one against the other. When you make the, as you talked about, if you choose a route that runs the stair step across Iowa, you probably impact landowners that you're actually crossing to a lesser degree if you can keep that line near the road right away, near the section line. But at the same time, there are costs associated with that in terms of you're probably going to affect more landowners. Well, you are mathematically. At least going to affect more land. And you're going to have some issues with operations in terms of the corners you turn. Now, obviously, the pipeline can turn corners. It does. You saw the map, and it at some, they can either bend it gradually around, or they can make a sharper corner if they need to. So there are options there, and those are just all things the board's going to have to consider and weigh in making its decision.
I'm learning a lot of things, as you know, and one of the things that I question is, if the route is an issue by the utilities board, is this the best time for the utilities board to be looking at the route after the hearing if we're really thinking that there should be different requirements? I don't know that that's a question that I want you to, how would you answer that?
Basically, sitting here today, I'm not sure what other options we have, short of perhaps, you could ask the pipelines to consult with some entity other than the board, which is going to ultimately make the decision on the route, but to consult with some other group, perhaps the consumer advocate or someone like that, on the route before they ever file it, before they notify the landowners, to give them a check on, a reality check of some sort on the route. I don't know that the consumer advocate would be the appropriate one for that either, but short of something like that, it's hard for the board to weigh in early on what's going to be an issue in the proceeding down the road.
And I think really where you are is the pipeline company makes that decision initially and goes out and does all of their, work about, how much this is going to cost, where should it go. And so they're presenting that to the board for consideration. And I don't know if there's a way for at least the board to get involved in that process prior to the petition being filed.
We do during transmission cases. We have 3 or 4 different alternatives on just 6 pieces of property. And granted, because of the size of this project, that makes it difficult, but at least from the limited experience I have, I know that we see multiple different options. I also understand that from the testimony, one of the concerns is for safety and security of the line. But that kind of goes out the window with me when I know that we actually are labeling it every quarter mile where it is. And it's plowed under if it's in the middle of a piece of farmland, or forest land, or those types of things. Mr. Wagner?
Going back to the discussion of other parties discussing the route. As an intervener in the case, the OCA had the opportunity to determine or to provide comment on whether or not this was the correct route.
Yes, I probably shouldn't have used them as an example. They're not the best choice for that, and I don't want to hang them out as if they should have done something here that they didn't.
I don't want to hang them out.
That was first ones to to come to the front top of my mind,
Wasn't
that's
intentional.
not the right
Sorry.
place. Yeah. Now I owe John lunch or
Off
something.
Mike, he said he just
But any
did.
intervener
Any intervener
could
can
have
raise
brought
it.
up that there were, and I think there were some that said there were no alternative routes presented. But again, so that goes back to my question. Looking at the requirements of the petition, it just says the possible use of alternative routes. It doesn't, so.
The statute does not specifically require that the company present alternatives. It has that option. My understanding of the company's case here is that they're saying, in essence, they looked at the whole state in terms of alternatives through that GIS mapping system and considered all of the avoidance criteria or preference criteria that were in those data sets, and they came up with what they believe to be the best route, and that's what they presented. Now, whether the board agrees or not is the question.
How many parcels are there left unexhibited?
I think our last count was 307. I think some were filed maybe
I saw
yesterday.
a couple yesterday.
So it's a moving target, but it's, I would say somewhere around 300 or a little less.
About 20 or 30 are governmental.
You know, we've counted those.
10.
If you just give me a chance to find that. Jeez. Okay, our count is 8. And then there's one that is a foundation that, although it's associated with, I think Iowa State, it's not actually a state agency. So there's really, I guess you could say 9 that are in a similar situation.
How many of those 8? How many of those 8 are associated with Iowa State?
I think we'd have to look to get the specific number. We just looked at those who have indicated that in their briefs that the board should not grant eminent domain over their parcels, that if the board decides to grant the permit, they will negotiate easements with Dakota Access.
So the number of those parties is 8?
That's what our count.
Okay. So how many of the parcels are governmental bodies that didn't necessarily take that approach?
I think that's all of them.
Okay, so every H file that's a governmental body said, you don't have a right of eminent domain, but we're going to negotiate if the board issues a permit.
That's the way I read it. I don't have a perfect memory of each of them, but I know that we've received 3 or 4 briefs that said the same thing.
And I do have a question to follow up. One of my questions was regarding the property that is owned by the foundation of Iowa State University. My read would be that that is a private foundation and not considered a government entity. Is that the correct read, or because it's?
Well, that's the way we've interpreted it, and that's why the 8 is those who specifically is associated with the governmental entity, and then you have the 1, the foundation.
Therefore, we set aside those 8. We have 299 that remain that have not entered into any voluntary agreement. Of those, how many, I know we have the one brief that says if they just locate it here, do we know how many of those there are?
Well, it depends on how much detail you want to get into, and we're, on our issue list, we do have the individual parcels that we're going to address. I mean, we can do, if you want, we can move right to that, or there are a couple other issues that we could take up now, or we could go right to the individual parcels.
let's continue with whatever you have if I've diverted us off of that. Then back on the route issue, what authority does the board have to change the route?
So, if you're talking about the overall route, in other words, if the board were to decide that diagonal is not the right approach.
I'm, at this point, because I don't wanna get into those legal issues, I'm just talking about the 299.
Well, you've got the language in the statute that says they can, apply whatever conditions that they find to be, necessary or reasonable.
Are there any attributing factors that we have to keep in mind when we're reviewing the route on these 299 parcels?
Well, you have to, it's the same, I think, with all of, you have to weigh the evidence and look at what's being proposed and then what the alternative is. And so you still have to weigh that evidence to determine whether you think the route over that individual parcel is reasonable and supported by the evidence, or whether the landowner who's asking that it be moved has provided sufficient justification to have it moved.
I'd just add to that, there are some sort of common sense restrictions on the board's ability to move the line around. For instance, I don't think you could move it onto the property of a landowner who didn't receive notice of the public information meeting in the first place, or you probably wouldn't want to move it around on property without knowing whether you're moving it closer to a school or forcing it to go through a cemetery or some other exclusionary area that it shouldn't be running through. So, those will be case-by-case determinations as you look at each one to see what the options are and what are the impacts of moving it when you get there.
So how do we do that? Let's just take, we've got a specific H file that we say, no, it shouldn't be there, it should be somewhere else within that parcel. How do we determine if it's moving closer to a school or closer to somebody's building, or it's not preferential to that landowner to be in that spot? And now that we're done with the hearing, that opportunity doesn't exist.
Well, I was going to say the first opportunity for that to have happened would have been at the hearing if any of these parcels where the company is seeking eminent domain. Well, and let me back up. I should preface all this by saying you only get to this if you first decide to grant a permit and first decide that the route's okay. So you're down the road on this. But hypothetically, if we were to get there, certainly the company, if it felt that the line has to go across parcel H-17 or whatever on this alignment because there's an exclusionary criteria 200 feet or 1,200 feet off to the northeast or whatever, they had that opportunity to give you that information at hearing. They would have that opportunity to give you that information again in an application for rehearing if once the board issued its decision, if there were unforeseen consequences. But to the extent we can see them, that's something we obviously want to consider at the time of the decision.
Of the 299, the number we're going to use.
But I think the actual number we have is 296.
296, all right. Fluid. Not all of those property owners have shared their thoughts with us, if that is correct. We've heard from some, but some have not chosen to weigh in on this at all, correct?
Right. There's a significant number of those who either filed objections, filed, intervened, filed testimony, or came to the hearing and testified. But still, the large majority of those landowners have not expressed an opinion one way or another.
In the record.
In the evidence.
In the evidence.
Right.
So the board does have the authority particularly in those cases where someone, the landowner may have intervened or filed an objection and said, I don't like it going here on my land, I would prefer that it goes here or not at all, which was the majority. So the board, in that case, you think we have the evidence we need to make a decision on those particular H files? To say, move the route or keep it.
You should, yes. The parties have had every opportunity to present that, and to the extent that there is something out there that they haven't, they'll have that opportunity again if they want to ask for rehearing.
And just so you know, we have put together the, all of the information regarding those where the landowner has filed an objection, where they intervene, file testimony, or where they testify at the hearing, so that that is available for each of those parcels. And when we get to those individuals, we can work through those and kind of, so you can, if you have any specific questions about those, we can deal with those at that time.
Do we have that, has that been downloaded onto our laptop so we can pull it up versus looking on this? Is that correct? No?
So where that is we have an N drive that contains information that is accessible by everyone at the board. And in that N drive, there's a file that says dockets. And then in that dockets file is an HLP folder. In that HLP folder is what we've termed a deliberations folder, which has all that information. It also has a list that shows you, which is color-coded, which shows you those that have filed objections, those that filed testimony, those that appeared at the hearing, etc. All right, that's all from the record, yeah. We pulled from the transcript and from the pre-filed evidence and from the Exhibit H's. So that information is the kind of information, if you determine, that the permit should be granted, that's the type of information we will, the board will have to go through in reaching a decision on the eminent domain on each of those parcels.
And are we gonna, how soon do I need to have that on my lap, so I'm not looking it up here?
Well, I have about 2 more issues.
All right.
And then we can take a break.
And we'll have it done.
And then we can and then we'll take a break if that's okay, because I wanna make sure the technology desk is ready when we go to the individual parcels, so.
I have another question. We're talking, about those, landowners who had objections, where there are the 296 who are listed in Exhibit H.
Correct.
Hypothetically, if a decision was made to grant the permit and then look at the route, or look at the route without, however that decision process is, the impact of moving the route to someone who has signed a voluntary easement, can you talk a little bit about that? How does that work?
It's going to depend on the terms of the voluntary easement that was signed, whether that easement gives the company, what you're talking about, let me back up and make sure I'm clear on this, is if we adjust the route across a condemnation parcel and that causes the route of the pipeline to shift on the adjoining parcel, to some extent, what's the impact of that? And the answer is, it may depend to some extent on the terms of the voluntary easement. If it is very specific as to the approved route of the pipeline, the company may have to go back to those landowners in the adjoining parcels for new easements or revised easements. There may be additional compensation associated with that. Or the voluntary easement could give the company the authority to move the pipeline within reason or within specified boundaries for those purposes. So that's information we won't have. We don't see those voluntary easements when they're negotiated. It's something that the pipeline company will have to deal with, and if it causes a truly insurmountable problem, then Dakota Access in that situation would presumably be back here before the board, either seeking the reconsideration of the initial move on the condemnation parcel, or seeking eminent domain authority with respect to the adjoining parcels in order to get the new easements.
You're gonna stop me if I ask you a question you don't wanna answer, right?
If I can.
Hypothetically, if you reach the decision and you think that all the factors are in play, and you're looking at the route and those remaining parcels, can that come back at what Ms. Jacobs is saying? Are we able to do that at a later time? Does the statute allow us to address that, the actual route for those that require eminent domain after?
We have certainly in established precedent for cases more on the electric transmission line side where, due to a variety of circumstances, conditions that were encountered in the field when construction began or whatever, that the company would need eminent domain over a parcel that was not a part of the original Exhibit H, or in the transmission line cases, Exhibit E. And the board has reopened the record, had a hearing, and granted eminent domain over those parcels where it was necessary, shown to be necessary to do that.
Is there any case law on
That has not been challenged in court, to the best of my knowledge.
Yeah, so in that situation, it was moving off of a landowner that was originally an H file or an eminent domain parcel onto a different one, right?
I believe that's correct.
Okay, thanks.
But the one thing you have to remember there is it's moving on to a parcel that did receive notice of the pipeline. Because if you move to a landowner who did not receive notice, then it creates additional issues, so you have to go back.
I understand that. Everything is prefaced with, they were originally provided with notice.
Correct.
And the information, okay. Do you wanna move to your next?
Sure. And I think just in looking at the overall route and what Dakota Access is proposing, as you know, there's the easement issues and the agricultural mitigation plan. But in addition, in the reply brief, Dakota Access is also committed to doing certain things which address the overall route. And a couple of those we talked about yesterday. One is the $25 million insurance policy. And in addition, Dakota Access is committed to provide quarterly status reports to the board, and beginning July 1, 2016, and continuing until the pipeline is in operation. And then they've also committed, if at the time of the filing of the October 1st, 2016 status report, Dakota Access cannot represent that all construction and restoration in Iowa will be completed by December 1, 2016. Dakota Access will file with the status report a winter construction plan, including methods for construction and stabilization in winter conditions. And then another one, Dakota Access will keep record of all drainage tile crossings with GPS coordinates, and within 180 days of the completion of the project, will file with the board as-built specifications of the pipeline, including the location and depth of all identified drainage tile. And then we talked about they're going to file, Dakota Access is committed to file final versions of their stormwater pollution prevention plan and unanticipated discovery plans, and they'll notify the board when they have filed their final facilities response plan with PHMSA. Dakota Access also committed to file with the board permits, approvals, and other similar documents from the U.S. Corps of Army Engineers, the Iowa Department of Natural Resources, prior to commencement of construction. In addition, they state for the area and the workspace easement, but not over the trench, Dakota Access agrees to modify its agricultural mitigation plan to provide that the topsoil will be removed to a depth of 12 inches, or if the topsoil depth is greater than 12 inches, the actual topsoil depth, if requested by the landowner, provided there is adequate room in the permitted workspace. And finally, Dakota Access will place the pipeline underground with no less than 45 inches of cover to the top of the pipe in all agricultural land except where less cover is requested by the landowner and Dakota Access determines the request is prudent and otherwise lawful, or where there is a subsurface obstruction that would prevent Dakota Access from utilizing the 48-inch depth, in which case the depth will be in accordance with applicable federal and state rules. I thought it was important to get those in because some of those issues that were raised in the evidence and by the landowners, I think some of these commitments do address, and the board will have to consider whether those commitments are sufficient to address those landowner concerns, but they are provided in the reply brief and these commitments made by Dakota Access. Then moving on to then the easements.
Do you, are you gonna come back to any of those, or do you wanna?
We can talk about them now, or we can talk about them when we, when
Well,
we get
some
to.
of them relate to the ag mitigation plan, some relate back to the permitting.
Correct.
How,
So when you look.
just keep going.
Yeah. So when you look at those issues, they're gonna come up either with individual landowners or when the board addresses the overall route, those are gonna come up, especially with, the winter construction plan. And so it just, they'll have, that's the commitment, you'll have to weigh that commitment in relationship to the evidence and determine whether you think that addresses those issues that were raised at the hearing by some of the opposing parties. So then, with regard to the easements, and the voluntary easements, I think, are negotiated between the landowner and the Dakota Access, but you do have the easements that are being proposed for the eminent domain parcels. And as we discussed before, the eminent domain authority in 479B16 does limit that to the width to 75 feet. Dakota Access has asked for a 50-foot permanent easement, but an additional 100 feet for a temporary easement for construction. There's also they've asked for additional, where it's necessary, eminent domain authority for valves or for placement of other facilities as part of the pipeline that are necessary for part of the pipeline. Those easement issues have been raised by the parties with regard to the language in those easements. I think if you've looked at the brief of the Northwest Iowa Landowners Association, they actually go in very specifically into all those. I don't know that we need to address all of those now, but I think what's important there is that they have raised issues about some of the more general language or the language overall, and specifically with regard to access. And I went back and looked at Fry's Exhibit 4, which, when we were at the hearing, we spent a lot of time looking at the pictures in that exhibit. I don't know if you remember that, but that showed the digging of the trench in the various stages. But at the beginning of that exhibit, Fry discusses the various types of easements that are being requested, and initially talks about the pipeline easement, which is the 50-foot wide permanent easement that they're requesting. And this he describes as for operational maintenance activities, and also to protect the pipeline from third-party encroachments. In that Exhibit E, it states that the landowner can use the easement service for most previous land uses, but prevents permanent structures being placed on the easement. And then you have, access easement, which, that exhibit describes as, in that, as a defined access usually 50 feet wide to the nearest public or private, roadway. I know there's issues discussed, and I think you'll see that in, seen in the evidence in Northwest Iowa Landowner Association brief with regard to how that language is reflected in the easement that's that's being presented for the eminent domain parcels. And then there's that exhibit, Fry Exhibit 4 describes valve side easements and talks about how those are, how big they are, and the fact that they are tried to be positioned away from road right of way for safety, and that they're fenced in so that they're not accessible to the landowner or the general public. And then there's also, in that description of Fry Exhibit 4 describes launcher and receiver side easements, which are, it states in there that there are 3 sites within Iowa. I don't remember if that's the actual number that was described in the testimony, but that's what's in that exhibit. And those are again fenced in so that, for safety, and so they're not accessible to the landowner. So that's kind of the overall of the general easements. If you look at the Northwest Iowa Landowner Association, and some of the other briefs and some of the other evidence have raised issues with regard to the language that's in the easement that's been proposed for the eminent domain parcels. I think the one that maybe was discussed the most was the issue of the language with regard to valves, and that's an issue I think the board is going to have to address, is whether they think that language is appropriate or whether there should be some limitation on that valve language in those easements.
What legal authority does the board have to go into easement agreements that have been voluntarily entered?
You're asking, I think, about an issue that I don't know that the board or even a court has ever addressed. I think it would be very difficult for the board to go in and make changes to a contract that has been voluntarily entered into between 2 parties. But that's just, I'm not giving you a legal opinion, that's just looking at it in general. I think that's a difficult proposition.
So, and that would be my opinion, which is why whenever this issue is raised, I think about where the utilities board gets ahead of different items on notice and other documents, and we require that we get to approve them before they're entered into with customers or other individuals. So when I look at this issue, it's almost like the petition should have included, and if you have voluntary easement agreements, we want to be able to review those. But since our rules don't have that, we didn't, they've already been entered into. I think that it only applies to those that haven't entered, that may, that require that we authorize eminent domain should we get to that issue. Is that correct?
I think that's correct. I think that if the board were to want to get involved in reviewing those voluntary easements for reasonableness or for the terms and conditions contained therein, it would be a complicated process to implement, in part because we don't know how the negotiations between the landowner and the pipeline company took place. So for instance, if I can use a specific example of the valves here. If the board concludes that the company should not have the right to put in a valve on a landowner's property in the future because it hasn't shown that it needs it now, you could apply that to the condemnation easements. But to take that and apply it to voluntary easements, we don't know. It's possible that a landowner raised that with the company and said, I will sign a voluntary easement, but I won't give you that right to put a valve on here in the future. You're gonna have to come back and talk to me then. You wanna do that? And the company turned around and said, we'll pay another $20,000 right now to have that right. And the landowner says, well, that's okay with me, I'll sign that agreement. Well, that's his choice, and that's his freedom of contract to do that. And that's what we would have to be able to, if we were gonna engage in that kind of review, we'd need some level of comfort that we weren't interfering with the negotiations that the parties had undertaken voluntarily.
Do we do that in any like electric or natural gas or any of our other, is there any document that we require that we review? I mean, I know we do it with customer bills, right? Or is it just notices?
Yeah, we review, you're talking about rate case notices, we review the notice that goes out, we even review the notice in hazardous liquid pipeline cases, the notice is published and in electric. But in all of the, where the board has this routing authority and issues a permit or a franchise, those voluntary easements, to my knowledge, the board has not looked into the terms of those negotiations.
I don't see anything in the statute that authorizes us to be able to do that, and that's why I asked the question.
The other issue that where the parties have specifically the Northwest Iowa Land Owners Association have raised specific issues with regard to the language is the agricultural mitigation plan. And that's again very detailed, and I wasn't proposed to go through that at this time. I think if it's agreeable that what we do is take a short break and get prepared to go through the individual parcels at this time, unless you have additional questions about some of the other issues that have been discussed.
Yeah, I got to go back real quick to the changing of the route. The rules allow during construction a 600-foot change in route. Do those rules limit moving off of a piece of property, or so if there's a parcel that was I suppose either voluntarily or involuntarily the route, does that 600 feet allow it to move off of that parcel onto a different parcel, or does it inherently restrict it to that parcel?
And I'm going to give you the information that I understand. The 660 feet that's in the rule, and to give you a historical perspective, it used to be a quarter mile. So, but sorry, it used to be a half mile. So, when we did the most recent rulemaking that addressed that, we kind of limited that. But that's in case when during construction there are obstacles which are encountered that from an engineering basis, just you need to go around them. And but I would think in regard to your specific question that you couldn't move on to a parcel where there was not a voluntary easement that allowed that. In other words, you couldn't move on to a parcel where there was no voluntary easement, or you'd have to come back and seek eminent domain. So I think any kind of movement has to be, if there's a voluntary easement within the negotiation part of that easement to be allowed. And it's my understanding that since the board, with regard to eminent domain parcels, is limited in granting what they consider necessary as part of that, the rights of eminent domain, that would be to a specific route. And so I think if at least this is my understanding, that if the route needed to be moved outside of that 50-foot easement, then they'd have to come back and get additional eminent domain authority.
But only on those parcels for which eminent domain was originally sought and granted.
Correct, and since we haven't seen the voluntary easement language, I mean, what's been negotiated with each landowner, you know, if they could do that under their voluntary easement, then that's, you know, they can do that.
So what would happen if there were a voluntary easement and the route needed to change in that particular parcel, and the landowner then said, I changed my mind, or I don't like that route, no, or once they sign it, have they signed it?
Have you ever signed a contract that you went back later on and didn't like the way it turned out?
I'm sure I have.
And what was the result if you tried to go in and abrogate that contract?
Okay. But again, it may depend to some extent on the specific terms of that easement agreement. If it does specify a precise location, then the pipeline company would have to go back to that landowner, reopen negotiations, try and get a new easement, and presumably make additional compensation for that new easement. What they bought is a right to build it. If the voluntary easement is specific as to route, then what they've purchased is the right to build on that route.
Do we know, I don't recall in testimony, and I know I don't think it came up in hearing. Are there any properties that have a voluntary easement for which the route is not actually going over that parcel?
You know, I've never heard of that, but I can't tell you that it's not happened because we don't look at the voluntary easement.
Okay.
So for example, if the pipeline ran very, very close to the corner of a parcel, the 50-foot wide easement strip could overlap into the adjoining parcel, and the company would want and would need to have an easement across that little piece in the corner in order to be sure that no structures were built in that land. So it's possible.
Or I'm thinking and I don't know the approach of the company, but perhaps along the way they were, hey, if I can get a voluntary easement here, I'm going to do it on a certain parcel, but then later on got the voluntary easements to go, so we avoided that parcel altogether.
Oh, certainly, or if their plans changed and they moved off a parcel, they could have purchased easements that they won't use. That's a possibility.
Thanks.
I have a follow-up question along those lines, but maybe on a little broader. The 660-foot rule, obviously the board can't waive its own rules. That's not allowed. So if a route is approved, the board technically never gets to know what the final route is until after the construction begins because of the 660-foot rule, and then all the issues around the voluntary easements and notice that may or may not have been given. Is that correct?
While they're conferring I don't believe the 660-foot rule can overcome the notice issues. It's never going to allow it to be moved to a parcel where that landowner was not on the list of people notified of the initial public information. So that's just a critical part of being involved in this process. But beyond that, I'll turn it over to Steve.
I missed the response. I was discussing 660-foot rule.
Well, I think we have a number of questions related to the 660. So how would you like to proceed with those?
I think if you go, you ask them, then maybe when we take the break, for those that we need to get some additional information, we can get that for you and provide it.
And understand we also understand you may not be able to provide it today.
Correct.
Subject to check here. I think we use that in hearings. My understanding has always been that the 660 feet is primarily related to the permit. that if the company encounters conditions during construction that require it to vary from the precise specified route a little bit in order to safely construct the pipeline or to accommodate some need that couldn't be determined until you got out in the field and started construction, then they have that ability to do it without coming back here for an amendment of the permit every time it happens. I see that as separate from the easement questions, where if the easement specifies a specific route for the pipeline or a specific 50-foot corridor for the easement, I think it would usually allow them to move within that easement corridor. That gets into the question of, do they need a different easement with that landowner, and in particular, when it goes to the condemnation parcels, it gets them into the question of, do they have to come back here for additional eminent domain authority if they've condemned a route that it turns out they can't or shouldn't build on.
It just seems like there's some conflict.
There's different purposes being served at different times, different concerns, and to me, 660 feet really doesn't go to the easements at all. That's a little strong, but it's.
What I hear you saying then is, if we get to the point that eminent domain is addressed for any project that we have the authority as the board to put in there that this is the route, this is what we're granting the eminent domain for, and you cannot move that without coming back to us. Is that correct?
I think with regard to the eminent domain parcels, that's the way it's been interpreted, because you're granting eminent domain for a specific route over a specific piece of property in a specific location that you've determined to be necessary, and any deviation outside of that, I think they have to come back and get additional authority.
But again, we would want that in writing, correct?
And if you're talking about in writing, I mean,
As
that,
a condition,
right.
as a.
Well, that will be stated in the order. I don't think, I think our orders are very specific when it comes to the eminent domain parcels about what's being granted.
Well, I think the 660 and what that means is something that we continue to question, because we want to make sure we understand how it's actually applied. And I'm still not comfortable that I've been given all of the information as to how it is applied. I may get there, but at this moment, I'm still not completely comfortable with that. How does the 660 then apply to the voluntary easements?
Well, I think as we discuss, depending on the terms of voluntary easement and how specific that the language is there with regard to the easement itself, either it includes language that allows the company to move the line the 660 feet, or it doesn't. And if it doesn't, as Mr. Lynch indicated earlier, it'd be our understanding that the company would have to go back to the landowner and negotiate for that additional easement.
And was the 660 issue addressed in the informational meetings that have to be held prior to the company being able to go out and negotiate with landowners, so that the landowners had this information in their informational sheet?
I don't think it's an issue. I'd have to go back and double check, but it's my understanding of those informational meetings, that's not an issue that is addressed. I mean, I think.
When is it addressed with landowners that enter into voluntary easements?
Well, since we don't look behind the voluntary easement, I cannot answer that question.
Landowners are provided the chapter rules during those meetings, correct? Which is where that is located.
Correct.
Would you like to take a break, Mr. Wright?
prepared to go with the individual,
So that
parcels.
we can get ready?
Right, so we can get ready to do that.
Okay. We will recess until 2:30.
At this time, I will go down, we'll take this break, and then I'll come back just a little bit before 2:30. So stay